All right, good morning, everyone. My name is Andy Seelig. I'm the Executive Director of the Minnesota Voters Alliance. I want to thank each and every one of you for taking the time out of your busy day to come and join us this morning. What we're going to be talking about today is, as many of you know, is the U.S. Supreme Court case that we just got word, Minnesota Voters Alliance versus Joe Mansky. We won the case 7-2, and we're very excited. But before I get started, I just have a couple talking points, and then I'll turn it over to my co-plaintiff, Sue Jeffers, is with me, and also our attorney from Mormon and Cardall, Mr. Eric Cardall. And I'll keep mine real brief. But what this case is about, in short and simple terms, is it's not really about t-shirts and buttons. And that's what most of the media has reported thus far. This is all about t-shirts and it's all about buttons and pins. What got me interested in this case from the very beginning was this case was about an abuse of power. This case was a case that stemmed from a policy that came down from Ramsey County Elections Manager Joe Mansky, specifically targeting people he didn't like. And that is people that had Tea Party apparel. And now why he did it, you'd have to ask him. My belief is it's a political motivation that he's had for a long time. Keep in mind, Joe Mansky used to work for the Secretary of State's office, and I believe that he left there in the mid-90s when Mary Kiffmeyer became Secretary of State. He left there a couple days before he was going to get fired anyway. So we have to remember this is all about political motivation and political exploitation of a statute that was overly broad. That's what brings us here today. For many decades, there was no problem with that statute. There was no problems reported of any significance in any of the polling places until Joe Mansky came up with a policy that specifically targeted the Tea Party. And as Justice Alito and some of the other justices mentioned, and the problem that they had with it, not only was it overly broad, but it was all arbitrary. It was arbitrary and it was not even-handed. And those are quotes from Justice Alito. Now what does not even-handed mean? It means that election judges, if they don't like what somebody's wearing, they can turn them away. Keep in mind, folks, under that policy that Joe Mansky came up with, you could be turned away from voting if your shirt said WCCO on it or NPR. A lot of folks think NPR, WCCO, and other sources are political. So that's how absurd that this policy was. So I just want to mention that on the outset, and then I have a couple of opening statements. The First Amendment is alive and well because today the U.S. Supreme Court has stood up against Minnesota election officials, Ramsey County Elections Manager Joe Mansky, and others who have long sought to suppress conservative speech. This is one victory in the continuing battle with those in the media, on college campuses, the legislature, and elsewhere who are similarly determined to silence speech for those that they disagree with. In closing, the Supreme Court opinion today is a big victory for those of us who believe in the Constitution, the rule of law, and holding public officials and public servants accountable, especially those like Joe Mansky and Assistant Hennepin County Attorney Dan Rogan, who have no problem restricting our First Amendment rights without any legitimate state interest, as long as it benefits their own careers. And in closing, before I turn it over to Sue, I want to mention one thing for those of you who were not at the U.S. Supreme Court hearing. You may have listened to some of it on the audio. For those of you who have, Assistant Hennepin County Attorney Dan Rogan argued this case on behalf of the state of Minnesota. One of the questions came up from I think it was Justice Alito, it may have been Justice Roberts. And they asked him, what if somebody comes up to the polling place with something, let's just say it's NPR, and what if you're turned away? What recourse does that person have at that point in time? And Dan Rogan responded, Your Honor, it's real simple. They could just file a lawsuit if they don't like it. That's how absurd this whole thing has been for the last 8.5 years as we fought this. So this is a big victory for those who believe in free speech. And I want to pay one special thank you to the Pacific Legal Foundation out of Sacramento, who took our case on appeal. And the biggest thanks of all I owe to Mr. Eric Cardall, who will be speaking here in a moment, from Mormon, Cardall and Erickson, who took this case all the way from the very beginning in 2010 to through the Court of Appeals twice. We went through the 8th Circuit Court of Appeals twice. So with that, I'm going to turn it over to Sue Jeffers.
8 years we waited for this, 8 years, and we win. You're welcome, Minnesota. 7-2, I love it. Thank you to Andy Seelig, thank you to Eric Cardall, thank you to Pacific Legal. They both say a lot, so I'll stop here. Thank you.
Thanks, Andy. Thanks, Sue. On behalf of my clients, Minnesota Voters Alliance, we want to thank the U.S. Supreme Court for this decision. What a wonderful institution where people who have been alienated by government official action can bring a petition, have it granted and reviewed like this. Can you imagine all this unnecessary alienation at the polling place that has occurred because election officials have been turning away people with political apparel on their or political statements on their apparel. And so what happens here is we need to take a brief moment to think about how we got to the U.S. Supreme Court. If you recall back in the 2010 election, I believe the 2008 election was the controversial Coleman-Franken recount, and the 2010 election was about election integrity, and there was a lot of interest in that because of the reversal of fortune. So you have to go that far back to look at when the Minnesota Voters Alliance sort of organized, when it got interested in this issue of election integrity and started representing people's interests in this regard. And it's true that Ramsey County election management official Joe Mansky was training election judges to turn away people wearing political apparel, particularly conservative apparel. There was a letter written to the Secretary of State, Mark Ritchie, at the time. I thought nothing would come of it, because if I wrote a letter to the Secretary of State saying, hey, knock it off, you can't pick on people wearing conservative apparel, that would be the end of it. I actually thought that. I thought, Andy, I'll write your darn letter, but this will be the end of it, right? And then you know, it just sort of surprised me, because it was such a common sense point that if you're going to ban political apparel, you got to ban all political apparel, not just conservative political apparel. And so I grew up in River Falls. I'm homegrown. The Minnesota Voters Alliance, by the way, is homegrown authentic. These members of this organization are people who live in your neighborhoods, and they focus on one thing, and I think Chief Justice Roberts mentioned it, that the mission of the Minnesota Voters Alliance, this is at page 4, and this is very important to understand. Petitioner Minnesota Voters Alliance is a nonprofit organization that seeks better government through election reforms. No organization has been more pilloried in the press, more pilloried by progressive organizations than the Minnesota Voters Alliance. They're just your neighbors. They just wanted to make government better. They wanted to make government better by doing things. You know, it's one thing to fall in love with the idea of doing something. It's a whole different thing to do things. And the Minnesota Voters Alliance has been doing things. In this case is an example. Now, so we had the people turned away from the polling place in 2010, including Andy was delayed several hours from voting because he was wearing political apparel. We brought the lawsuit. The positions kind of become cemented. We lost on jurisdiction, then the 8th Circuit reversed on jurisdiction. We lost on the merits. We lost on the merits. Pacific Legal Foundation joined the team, and we brought it to the U.S. Supreme Court and won. Now, the decision is very broad. If you look at the appendix, this decision affects 32 other states in addition to Minnesota and District of Columbia. So the states are listed. These are the statutes we're complaining about. It's happening in other states. In all the other states where it's been reported on that people have been stopped for wearing political apparel and lawsuits were filed, they were quickly settled. For some reason, our government was much more obstinate. I gave them plenty of opportunities to settle the case. I mean, my God, it was 8 years. They could have changed the policy. The U.S. Supreme Court said they didn't change the policy since 2010. I mean, think about that they're still banning Tea Party t-shirts, but they don't have any sort of specific regulation on MAGA hats or Better Together or whatever hats were worn in the last election. So there was just a lack of care to details. There was government mediocrity. But I think the real story today is a much more positive one. And that is, everyone in Minnesota wins because regardless of what they wear, if it has a political statement, they're not going to be told by an election official, you can't vote because you're wearing that. And the idea of not alienating people when they're voting is a very good one. And we all should stand on that proposition. The government here, the Hennepin County, Ramsey County, the Secretary of State stood on the proposition that it was okay to tell people that they can't vote based on what they're wearing. So this sort of, progressive narrative that we've lived with, I've lived with, probably since I was born, that somehow conservatives are the people who are trying to intimidate voters, it's over. It's over. Because your progressive election officials told conservatives that they couldn't wear conservative apparel to vote. It's over. It's a new discussion now. Okay, can we get away from the bipolarity and we just make sure we have election integrity? No more ideological bipolarity. No more Republicans and Democrats, liberals and conservatives. Let's get to work and have the best election system in the world. Not just say it, because we've been saying it forever, but actually do it. And we do it by getting rid of unjust laws like this one, and the U.S. Supreme Court gives us a boost and gives the Minnesota Voters Alliance a boost to accomplish this agenda of having as perfect an election system as possible. So we're so happy and appreciative of the U.S. Supreme Court. We're appreciative because this redeems all the work the Minnesota Voters Alliance has done, and the Minnesota Voters Alliance is going to take this gift, really unexpected fruit received in the vineyard the Minnesota Voters Alliance has been working, and use this as a platform to accomplish greater things for the people of Minnesota. Thank you very much, and Andy, you want to take questions? Or?
Absolutely.
Yeah, Andy, how do you think this is going to change voter behavior, if at all, in the next election, let's say? Will people be wearing different things, hats, shirts, anything like that?
I certainly can't, thanks for your question, Pat. I certainly can't predict what people are going to do. I think overall, it'll give them more, I think people are going to see it as a big victory as they pay attention to it. And we're seeing people keep in mind, we had the ACLU as in one of our many amicus briefs filed on our side. So we had people from both sides involved with this. When we went to California right after the Supreme Court hearing for an event out in California, I woke up the next morning on the way to fly back, and there was a big headline on the front page of the LA Times about this lawsuit. And the LA Times actually came out and said, we don't need a dress code when we vote. So, this really touches people from all walks of life.
And walk us back, if you could. What happened to you when you went to vote in 2010?
Well, I went to vote, and I had my shirt said Tea Party on it. Some of the correspondents said I had a button on. I don't recall. If it's in the brief, then I had a button. But that's not why I was stopped. I was stopped because my shirt said Tea Party Patriots on there. And so when I walked in to vote, it was at St. Andrew's Church in Eden Prairie. And I went over to the table and I asked to sign in, and they took one look at my shirt, and she called the head election judge over. And that woman, I forget her name, she came over and immediately looked at my shirt and told me that I couldn't vote unless I removed my shirt or covered it up. So that's that's how that went down. It was that simple. There was no question.
Right, and then Andy called me up, and then I went over to the polling place, and I was about the most ineffective advocate you can imagine, because I arrived and nothing changed. But thank God for the media, because when the media arrived, everything changed, and Andy was allowed to vote in his t-shirt.
Do any of you anticipate the legislature at any point trying to craft a law that is not so broad and not so open to interpretation that would restrict some of the apparel and whatnot?
Well, yes. The challenge with the Minnesota legislature, and this is a kind of nerd wars, right? So I apologize. But what happens is you win these cases, and I've won several against the state of Minnesota, and then the legislature doesn't respond to the federal and state court decisions. So if you go to the legislative website, they actually have a collection of statutes which have been found unconstitutional. Now these might be lawsuits brought by different parties and so forth, but the courts have said, this statute is unconstitutional. So the people think, well, okay, we have three branches of government, so the legislature is going to fix the statute. No, that's not what happens. What happens is that you have a statute banning political apparel, and you have a U.S. Supreme Court decision saying it's unconstitutional, then generally the legislature won't change the statute, so your poor election official won't know unless they know about the U.S. Supreme Court decision. And this is another example of a problem we have in our election laws in Minnesota, is that the courts and the legislature and the executive branch don't work closely together and closely enough, and so you end up having these unconstitutional laws not repealed.
So will you be urging the Secretary of State to educate then election judges to be aware of this ruling as opposed to the
Right.
statute that is still on the books.
Right, it's a great populist point. You can't point at the government without pointing at the people. The people will work through the Minnesota Voters Alliance and other groups to get the Secretary of State to sponsor legislation that will change this law. But almost as important is that we'll be supporting, through the Pacific Legal Foundation, legislative changes in the other 32 states in the District of Columbia. Because remember, we're all Americans, and in these federal elections, particularly for president, every vote can count. So we have an interest in making sure these statutes are fixed in the other states as well.
But you have an election this fall, and we won't be able to change the law before then. So to piggyback on Tom's question, you're urging the Secretary of State to do something?
Oh, right, well, Andy, that's
Andy.
more of a legislative question. Go ahead.
Again, that's a good question. I guess that's not, it's not a big concern to me, what happens. I mean, if somebody comes in and they get turned away, we can deal with it at that time. I think that if a person does come in with something on their shirt that the election judge doesn't believe is non-political, if something was, the law says the person still has to be allowed to vote. Okay, so their name could be taken down for prosecution, but that would just be thrown out. So I don't think it would be an issue.
I guess, observing the Minnesota Voters Alliance and kind of how they do their business, it's sort of a populist organization, so they kind of respond. So one of the things that's going to happen here, Andy doesn't know this because we just got the decision, is that Minnesota Voters Alliance has a network through the election judges. And so after today, we'll start getting questions from the election judges. And that's where the problem for the system is, because the election judges will read the U.S. Supreme Court opinion, and they'll be of the mind that they can't stop people with political peril. Then others who won't have the U.S. Supreme Court opinion will think otherwise. And so you have conflict amongst the election judges again, like we did the last election, regarding the questions that asked ineligible felons. And so this idea of these election judges, they're so important because they're so smart. They're actually kind of public officials, but they're not. But they're really concerned about our election system. And they're coming to Andy and me and they're saying, why can't we get this election system right? Why are we allowing ineligible people to vote? Why are we stopping eligible people from voting who are wearing the wrong things? I mean, these are real practical questions. And so here you have a grassroots organization working practically. Andy's organization is homegrown, authentic, anti-expert, anti-elite, pro-democracy. Those are the things you want to see in an organization. And when you have an organization that takes the subject matter so seriously, like election integrity, then it can do something that's so extraordinary. Chief Justice Roberts mentioned it. We can get better government. And it is so hopeful, that message, right? The message of the U.S. Supreme Court opinion is, if you're a person and you have a group and you want to make better government, you're willing to work hard to do it, you can accomplish it. And in this case, the U.S. Supreme Court helped. But Andy's organization isn't any different before or after this opinion. It's the same organization, and it's us. And we're trying to improve election integrity, election processes. And we're really disappointed with the election officials here, Secretary of State, Hennepin and Ramsey County officials, because they don't get that. There's something else going on. And so we're going to continue to work hard until they improve. And that's all the people can do. I mean, we're going to have a big government in our post-industrial society, and so what we need to do is make sure it's a very good government. And the only way to do that is to work. And you work by electing candidates, you work by going to hearings, you do this, do that, lawsuits, which I do, and that's how you do it. And so we've accomplished that. And I think with respect to that issue, I think the Minnesota Voters Alliance and the election judges will be involved.
Eric, somewhat of a technical question for you, but Justice Robert writes that this law restricts First Amendment expression, but if you dig in on page 13, it seems to me what it kind of turns on is the fact that state law doesn't define the word political. Is that kind of the crux of the case right there?
Right. I think there's a part that, I suggested that the consequences of the decision were broad because the 32 other states have statutes that are similar. But you're right, that there was this issue regarding the policy, and was it overly broad? And it was overbroad because the position of the government was that the election judges would need to know what election issues were at stake in the candidate election or ballot election. And so the example that he gave that I sort of liked was the one, I think it was around that page, where he said that, it wasn't so long ago with the Dale U.S. Supreme Court case on the Boy Scouts, that the Boy Scouts were controversial in an election issue. So would we turn away, a scoutmaster in uniform? from voting because the Boy Scouts are controversial. That's how broad it was. Famously, the government argued at the U.S. Supreme Court that a T-shirt with the First Amendment would be allowed, but a T-shirt with the Second Amendment would not be allowed. That got a lot of attention nationally. By the way, I should mention that Pacific Legal Foundation, I believe, is having a press conference in the Heritage Foundation building right now. So they're also, there's a lot of attention in this case. So on this, I think the narrow part of the decision is what you're describing. And so the broad part is that the same issue exists that appears in 32 other states.
Do you believe that there's a way to craft a new law that would address some of the concerns that the state has had about voter intimidation and persuasion at the polling places? Or does any law risk giving election judges too much say in exerting their own political opinions to, say, block you from entering a polling place?
I got the answer to this one, and that is, part of the craft, as everyone knows, I represent people left of center, right of center. So what I'm doing is a legal craft. And so from the very beginning, we didn't challenge the sentence that banned electioneering at the polling place. We just went after political apparel. So the U.S. Supreme Court, example of the narrowness of the decision, the U.S. Supreme Court wasn't really addressing electioneering because we all agreed it was already prohibited. And so our view is that the sentence should be repealed and just let the electioneering sentence deal with that sort of thing. Because I suppose, and this came from the U.S. Supreme Court argument, that you could see someone electioneering by having all their supporters wear shirts and kind of create a commotion. Well, that would be electioneering. And so that's not what we were talking about. We were talking about people passively wearing messages like Tea Party T-shirt, freedom, liberty, cut taxes, that sort of thing.
I was going to say the same thing. You just said it a lot better.
So is there, do any of you see a need for some kind of a replacement law, or does the removal of this sentence of the statute solve everything?
Well, going back to the earlier question, we're not quite sure when the legislature doesn't repeal a law when it's unconstitutional, what happens. What if someone disagrees with the U.S. Supreme Court opinion but agrees with the law and sees the law hasn't been repealed? So it creates a sort of uncertainty, so the law should be repealed to conform to the U.S. Supreme Court decision. With a pending election, we're not sure that'll happen because that'll require a special session at this point.
Andy, what do you anticipate polling places looking like in 2018? Are people going to treat this like the Wild West and make it look like a political convention at polling places?
Good question, Tom. I don't think there's going to be any problem. I mean, there hasn't been a problem. There hasn't been a problem for decades and decades. The thing that started this whole problem was Joe Mansky. Joe Mansky decided he felt the need to come up with a policy to target people he didn't like. He believed threatened his position. He's a lifelong Democrat. The last thing he wanted is to get Republicans elected that had to do any authority over Ramsey County elections. So when you start talking about lifelong career politicians, those of us average citizens and those in the media should be watching very closely. But the one thing that that I like to say that's so cool about this whole thing is just how an average person from St. Paul, Minnesota, can take a case, any kind of case, and stand up and pull up a little bit of resources and go all the way to the United States Supreme Court. That's a pretty cool thing. And win. That's an even cooler thing. So the hope that gives me, just as election results are. Now keep in mind, and let me go off on a little bit of a tangent. We're certifying elections right now, and we don't even know the results a year and a half later. We're talking about tens of thousands of votes ballots were cast, and to this day, even after a legislative auditor report that just came out in March, they don't have any idea who won the elections here in Minnesota back in 2016. So I'm just giving you a little taste of our case next Friday. Hopefully all you folks can attend. It's going to be a packed courtroom, and that's going to be in Ramsey County District Court in courtroom 1570 with Judge Frisch. But that's the main reason why we're here. This was just kind of something that happened on the side that Joe Mansky got a wild hair and decided he needed to do something because the Tea Party was really growing, and I don't think he liked that.
Yeah, it's interesting too. Thank God for the media again, because you guys are doing the hard work. It was really funny after watching Andy get pilloried in the media by these progressive organizations and so forth. The legislative auditor, I think, felt forced to do something on Andy's issues. And then if you read that legislative auditor report that came out a couple months ago, it's sort of like Jeez. Andy's right about all these things. We don't want to look too closely because it would undermine election integrity. No, we're grown-ups. You know, we know our election system's broken. This is one example. We can know the truth, and Mr. Noble should have given us all the truth. I think they looked at only 400 ineligible felons who voted, and they only could validate like 15 were actually eligible. And this is just a sampling, so if they'd gone further, they would have seen exactly what Andy's been complaining about. And of course, the conflict in 2010 rests on the ineligible felons voting in 2008, so it goes back to Coleman Franken. So if you recall the sequence, Coleman Franken 2008, Minnesota Voters Alliance forums, they're concerned about ineligible felons voting in 2008, causing the election to turn towards Franken, and then this was sort of the retaliation. So that's a Minnesota background, but if the media hadn't covered these things, we wouldn't have that narrative. It'd just be the government's narrative. And so we're very appreciative of the media doing these things. And with respect to the U.S. Supreme Court, it's so few cases that are taken by the U.S. Supreme Court, and I'm just really happy that we have this decision, because I think it's an important legal decision, but politically and culturally it's important too, because I think that this is a liberal state, but those of us who are conservative or maybe populist, we should feel welcome too. And at the polling place, it's really important that progressives keep in mind that they be hospitable. You know, you can't turn away people because of their political ideas disagree with you. That's just wrong. And so we need liberals and progressives to understand what conservatives are embracing, and that is hospitality. And the polling place is one of the most important places to understand that, because we want everyone to feel welcome to vote. Thank you so much.
Thanks.
Thank you.
Thanks, everybody.